So hello folks, I'm Andy Davis. I'm the Director of Research here at the Decent Center. It's good to have everybody coming in. I will just start talking, but please do not worry, you're not missing anything important. I am just introducing everybody, and in a moment I'll pass it over to our speaker to actually begin the really substantive and important and interesting part of today's session. Um, we're based at the Decent Center down in SMU, Denver School of Law in Dallas. We do work on public defense in particular, also prosecutorial decision making in cases, and we have a special focus on rural areas in some of our work. We're a policy and research unit based at the law school here. And we're delighted today to be joined by Emily Galvin-Almanza, who's talking about her book, The Price of Mercy. And it has been going around the country, as far as I can tell, talking about it with many, many audiences. And so we're delighted to have her here today. The structure that I'm anticipating today is that I'll ask Emily a few questions. She will speak expansively about her book, and we will do that probably for 30 minutes or so. But I hope that in the same spirit, folks in the audience will be thinking about the questions that they would have for Emily. We do have an hour to fill. And both Emily and I certainly have the problem that we will talk for an hour if we're allowed to, and I hope you won't. So in the same spirit, I hope you'll come up with questions. I will pause. You can by all means use the hand raising feature in Zoom, and we will turn to you. We're a small group, so we'll be able to make space, and everybody will surely have a chance to answer ask their questions by the time that we're done. But Emily, I wonder if I could pass it to you to start with, and perhaps you could introduce yourself and describe a little bit about what it is you're doing in this book.
Sure. So first of all, so glad to be here. Happy to meet you all. Happy to see some old friends in the room as well. Hi, I'm Emily. I was a public defender for a really long time, first in Santa Clara County, California, and then after spending some time litigating three strikes, life or resentencings, I went out to Bronx Defenders. Um, and since leaving Bronx Defenders, I've actually been working with public defenders all over the country to try to help them in expanding their practice. Defenders who are hungry to move towards holistic defense, sometimes dealing with resource constraints or other restrictions on their ability to expand. My program, Partners for Justice, helps those defenders sort of attain the results of holistic defense through sometimes very creative means. But the reason I wrote this book was really, building Partners for Justice has been an amazing journey. I've spent the last 8 years bringing this program from 2 public defender offices to over 46 locations. Is it 40? Over 40, 45 or 46 locations around the country. We've worked with defenders in 20 states at this point. And that has involved a ton of legwork, talking with people who are well outside our system, well outside our sector, who are suspicious of our sector. Like I spend a lot of time talking with people in philanthropy and also local, state and county lawmakers about why they should care about public defense, why expanding it is good for not just accused people, but the community writ large. And at a certain point, I was like, if I could just write down everything that I'm telling people over and over and over again, telling them in person seems to work really well. That's how we grew so fast and and so far. But maybe I could write it down and that could be useful to more people than just me. I mean, 100 pages of my book is citations because the data in our sector is fascinating and copious and often very supportive of really, really decarceral, care-oriented ideas. So I wanted to sort of put out a book that can get a layperson who doesn't care really invested in the transformation of the criminal court system and really clear on a lot of different solutions that have been proven and work really, really well. And maybe if I get them worked up enough, they'll vote differently or bother their county board of supervisors.
So Emily, you've perfectly accurately described the book. It is citation rich, and it's also narrative rich, and it actually begins with a description of your first experience of the criminal justice system. And I wanted to ask for you to sort of sketch this path for us a little bit, because actually, although you are now operating at this level where you're consulting data and you're thinking about policy in this macro level, you also are actually coming from this place where you are on the ground defending one person at a time as a public defender, and even before that as a defendant. Could you explain to us how what you saw then is informing what you're saying now?
Yeah. So the book opens with me getting arrested. When I was a young person, I went through a really, really dark period. You know, a lot of substance abuse and crime and chaos. And so my first experience of the criminal court system was not theoretical. um, I've been a person who needed to be defended, and I've been a very frightened teenager standing in a courtroom, not really understanding what was going on around me and not really knowing what was going to happen to me next. Um, I got really, really lucky in that, I mean, obviously, I walked into the courtroom with a lot of different forms of privilege. I was the only white kid that I could see in the courthouse. I had a college acceptance letter in hand, even though I was only 16. I was really good at like studying, but also doing drugs. So it's just um, like many people. Um, but the point is that one of the luckiest things that happened to me was I walked into the courtroom of a judge who was a very, very unique individual at a time when there were almost no black jurists on the bench in Boston. And I say at a time as if it was such a different era, as if we aren't currently operating in a profession that is nearly 80% white. But Judge Leslie Harris had grown up on the south side of Chicago, and he had had a lot of different life experiences that come with growing up in a low-income community where violence is common but also complex, where the same kids who kind of haunted his neighborhood were the guys who forced him to go back to college when he tried to drop out because they said they'd kick his ass if he didn't. He had experienced crime. He had considered involving himself in crime. He brought a wealth of life experience and also professional experience. He'd been a prosecutor, a probation officer, and a public defender by the time he reached the bench. And this created in him a really unique perspective where he was determined to treat every child in front of him as if they had value, as if he was going to look for all of our highest promise instead of our threat. And so, you know, for me, that meant that he called me up to the bench and he asked me what I was doing there. And I said something stupid because I was scared and 16. And he said that he was going to not let this case ruin my life because any conviction would have cost me my college acceptance. It would have totally changed everything that followed. He said he was going to dismiss it and expunge it and that he didn't ever want to hear from me again unless I had done something good with my life. So because of him, I had the luxury of time to sort myself out instead of being sorted by a punishment system. I got to go to college. I got to go to law school. I got to become a public defender. And years later, I got to write him and tell him what I had done. And it actually wasn't until I was interviewing him for the book that I discovered that my letter had reached him at a moment where he himself was in crisis. He had had a child in his courtroom had been killed. And he was struggling with the idea that if he can't save the kids who are in his courtroom, what is he still doing on the bench? He was about to actually leave the bench. And happily, my letter saying, hey man, like I'm a public defender and all my cases are your grand cases, reached him at a moment where it gave him the boost he needed to stay on for a few more years, which was really wonderful. But I tell this story because for a couple of reasons. One, it calls into stark relief the difference in treatment across our court system. I mean, obviously, I had a lot of luck in my case and a lot of privilege. My first day as a defender, I was walking into rooms in East Lake Juvenile, which was the busiest juvenile courthouse in Los Angeles at the time, meeting kids who had done stuff that I had quite literally done myself not that long before, except for they were black and brown in East LA. And I hadn't been. And so, you know, being a public defender who's done a lot of stuff that your clients wouldn't expect you had done and who's also had a lot of experiences of that create more commonality than than anyone might expect, I think has made my practice both filled with rage and also focused on the human concerns in a way it might not otherwise have been.
Mm-hmm. Thank you. Speaking of that practice, then um, the at our center, we're very interested in what we call this idea of day one representation, which is the notion that a person on day one after they've been arrested should have access to a lawyer if they want one and a court that can assess their release,
Yeah.
which is not universally true or even required around the country. Um, and as researchers, we look at this, as a researcher, I look at this anyway, and statistically anyway, you can often show the real major benefits of these kinds of programs when they're present. But I actually wonder if you could speak to it from your experience as a public defender that you were just getting to. I mean, you go into a court, and this is the thing I'm asking selfishly because a researcher would find this very difficult to capture. You go into a court and you're meeting somebody for the first time. They've no reason to trust you. You have to persuade them that you're there to help them, which must seem very implausible in that moment.
Yep.
Um, and yet, what you write about in the book is that this pre-trial moment, this early part of the case, is so life-altering.
Yep.
And there are these rules in some places that prevent lawyers having access to evidence, and so it's legally um, contingent in a lot of ways.
Mhm.
What difference in your experience does having that early access make? And I guess my little sub-question is, how do you get somebody's trust in that moment?
So that's two different answers, really. I'll start with the why. Why is it so important? I mean, in New York, I had the privilege of representing people fast. New York gets everybody seen within 24 hours of arrest. I mean, sometimes it takes longer if the person's hospitalized, but generally, like, there's a lot of pressure on every system actor to get someone in front of a judge within 24 hours. And that is fantastic because it means that I am meeting a person in the moments after this crisis in their life. I'm there in time to see their injuries if they've been hurt, um, things that can quickly fade. I mean, sometimes it's big things like, we saw a lot of police violence and I saw the aftermath of that firsthand and could document it. But sometimes it's insidious, like the red marks of having been handcuffed too tight for too long. When you notice that on person after person, you start to detect patterns in forms of police abuse that could otherwise go unnoticed. Also, the investigation was fresh. One thing that I feel like lay people never understand is that the quality of police investigation across the board is fairly low. This is why police clearance rates are really low across most categories of the offenses we actually care about. And it's also, an experience where, as a defender, it was routine that I would be told there's no video in this case. And then a defense investigator would go out and find like 4 different videos for the case because we were investigating within 2 weeks of the incident. So the video hadn't been lost, it hadn't been recorded over, people's memories were fresh. Um, the scene still looked like it did. If there were unique things about the scene of a crime, construction or temporary factors, a celebration, it hadn't been all packed up yet and moved away. So basically, when I think about early representation, or not, I should even call this early representation would be pre-arrest. When I think about appropriately prompt representation, it falls to me into the category of a thing that is often portrayed as a defense advantage, but which is in fact a justice advantage. If system, shapers, if policymakers want to claim that they care in any way about finding out what really happened, or truth, or accuracy in our court system, or having the court system produce something like justice, it is completely contrary to that to say, oh, but we don't need to do any further investigation beyond whatever police have time for weeks and weeks and weeks following the incident itself. That early investigation is what discloses bad acts on the part of law enforcement and also any vital flaws or revelations about the accuracy of the charges. So basically, it is a crucial accuracy measure. In terms of building trust, like, yeah, I walk into interview booths like looking like the whole system, right? I'm like the fifth well-meaning white lady who's asked for someone's trust that day. Um, a lot of it for me comes from just being as honest and accurate as I possibly can be about exactly who I am, what I do, and everything that's going to happen next. And generally, if I can provide insight and accurate guidance about what will likely happen next and what we are going to do together as a team, myself and the client, if we can begin to strategize, I feel like trust is built through consistency, reliability, and strategy. So if I do what I say I'm going to do, if the information I provide is accurate, and if it is clear that my interest is in creating a plan together that leads home, those things are my core trust building tactics. Um,
Yeah.
there have been times when I have revealed things about myself that I wouldn't ordinarily reveal to a stranger. It's a case by case determination of like how much understanding I disclose in particular moments. But I also have always been proud. I love the way we were trained at Bronx Defenders to use narrative in the bail process and to not deliver. There's so many jurisdictions where you go watch arraignments and you get lawyers who are like, here, wait, I gotta do it with a notebook. Your Honor, my client has lived in the jurisdiction for 4 years. He is employed. Um, that's not persuasive to anybody, right? But we were trained to tell stories and to think about what do factors in people's lives indicate about their ability to return to court. So things like my client is so trusted at work that his boss gives him the keys to open and close the shop. Or my client is so good at showing up for stuff that he takes his mom to dialysis 3 times a week. And if he weren't reliable, she couldn't survive. That's how reliable he is. And thinking about ways to enter into each narrative in a different moment of the story so that your stories sound different one from the other, different enough that the judge can believe again and again that yes, this new person is different and special enough to warrant release. And yes, the next new person is also different and special enough to warrant release. I think the last piece of my trust building was delivering results. If my client heard the things that were most important to them represented in the way I argued, if they could tell that I was listening because of what I said next, if I took the time when they didn't understand something on the record to stop the proceedings until they felt comfortable, like they understood. These are the little touches that make someone feel seen and heard. I will also note these are the things that we consider normal for high paid defense. And a continual bugaboo with me is this idea that poor people should get less good stuff. Rich people should get beautiful drug treatment programs that smell like eucalyptus. Poor people can go to a linoleum lobby that smells like pee, and that's fine. Rich people get a defense lawyer who will stop the proceedings if their client doesn't understand what's happening. Poor people just got to figure it out later. I'll come talk to you back in holding. We need to stop as a defense community countenancing any of that and start insisting on truly, truly equal resources down to the smallest detail of care and service. So I've talked a lot. I'll stop.
No, thank you. Thank you. I appreciate that. I will reiterate to folks that please do raise your hands, put your questions in chat. We will get them asked. Or we'll invite you to unmute and get them asked. And so one of the things that one of the most ambitious parts of the book is where you start to talk about how this kind of ethic, perhaps it is, or service provision that you're talking about that could come from public defenders, that sometimes public defenders do deliver and sometimes they don't, can have far-reaching consequences. And we've talked about the very beginning of a case so far, and perhaps we're already edging beyond that. But you actually specifically even suggest that skillfully delivered, adequately resourced, conscientious public defense can impact public safety, which is itself also a contested and tricky term. So could you explain what you are thinking about when what you mean by that?
Yeah. So I'm going to start with really basic public defense, like no frills, no holistic, like just the delivery of adequate criminal defense services. All right. So we know with a fair degree of certainty that incarceration is really damaging to people across a multitude of facets, right? Exposure to pretrial detention is criminogenic. There are multiple studies showing that the length of exposure to pretrial detention increases the likelihood of a person's future arrest. In other words, being in 2 days makes you more likely than someone who was in 0 days. Being in 7 days makes you more likely than someone who was in 2 days to commit a future crime. We also know that incarceration is deeply damaging to health. Every year of incarceration shaves 2 years off a person's expected lifespan, adds 10 to 15 years to their physiognomy. 80% of people who go in come home with some kind of long-term health concern. And we know that incarceration is really damaging to livelihood. Incarceration cuts a person's expected lifetime earnings in half. American families lose over $300 billion a year due to the prior incarceration of their family members. So we know that just stepping in is really bad for people across a multitude of ways. I haven't even talked about educational attainment or social stigma or political voice. Like, you could go on for a while on this. So a defense attorney who is able to prevent incarceration has done a few things. Thing number one, the less exposure they've had, the less of a criminogenic effect incarceration can have. I mean, literally, there was even a study came out like 8 months ago, showing that even a felony conviction with no period of incarceration, just because of the impact of that felony conviction on a person's employability, can have criminogenic effects almost as strong as a period of incarceration. So defense that diminishes felony convictions, that diminishes separation of a person from their community, that diminishes exposure to incarceration, can make a person less likely to get rearrested in the future, and can also preserve a person's health, thus lowering public health costs to the community, because of course 80% of accused people are so poor they get a public defender. Those are people for whom we are paying for their health care. That defender is also preserving that person's economic participation and mobility. If that person does not have their lifetime expected earnings shaved in half, that person is more likely to be paying their taxes and shopping at the corner store and contributing economically. So already, even without any frills, we see the provision of criminal defense services having an impact across likelihood of future arrest, healthcare costs, and economic participation. Now let's add in just a few little bells and whistles. Like at PFJ, we bring in teams of client advocates that work on housing access, employment, employability, educational access, treatment support, substance use treatment, mental health treatment, transportation, compliance with court orders. Across all of our service areas, we have about at this point, almost a 90% success rate in delivering the services we seek to deliver. When you do that, you're doing a number of things. There's a lot of research suggesting that housing, income, and access to healthcare are highly influential when it comes to a person's likelihood of arrest. If they have a roof over their head, the ability to put food on the table, and the medicines they need, they're just much less likely than someone who doesn't have those things to get arrested. So when you take that initial impact defense is already having, and then you add on to it the ability to help a person get access to an appropriate treatment program, or the ability to help a person sign up for food stamps, get the benefits, the aid they need. If you help find a person a job, we land clients jobs a lot. Literally, in a study of our Oakland work, almost 70% of the time, if a person wanted help getting a job, we found a job. Almost 60%, actually over 60% of the time, if a person wanted help finding housing, we found housing. So we're delivering the things that research tells us lowers the likelihood of future arrest. So this is now we're seeing public defense have not only a preventative benefit in terms of a person's safety, health, and economic mobility, but an affirmative service delivery benefit. These are forms of aid prosecution can't do. They don't get people jobs in housing. Like every form of safety they have to offer, we know is actually criminogenic and damaging in a multitude of ways. The same thing with police. This is also informed by the fact that public defense creates this really unique relationship where our conversations with our clients are privileged and confidential. That means that if a person's circumstances are messy, they can be honest about what their actual needs are and what's actually going on. And you know what? I, as their defender, I'm not going to turn around and snitch the way probation would. I can actually, because I have good, real information about this person's life and needs, I can design a plan that is more responsive to their actual needs than any other system actor. And that means that the help I offer is more likely to stick than the badly fitted help that the court or prosecution or probation or anybody else can offer. I mean, every defender knows that we're the people in the room making the diversion court work because we're like, Judge, that program's not a good fit for my client for these reasons. This other program would be a better fit. If that program succeeds, it's because the defender had the right information to make a better tailored plan. So my argument is that most lawmakers are really sleeping on the full effect public defense could have if built out and equipped to do the maximum good that we as defenders are capable of. It's not actually that expensive. Investing in more attorney roles so that people don't have psychotic caseloads, but also in more non-attorney roles, which are more affordable as budget line items even than the attorney roles, yields these massive benefits to the economic mobility, health, and safety of communities that governments could realize within 5 years if they chose to act.
Fantastic. Thank you very much.
Mhm.
I'm gonna we had a question from Cody in the chat, so I'm gonna defer to him. Cody, if you don't mind, I'll just read it out. He says, "Hi Emily, you mentioned part of the writing of your book was to relay issues of injustice with this system to laypersons. I work at the Texas Indigent Defense Commission, where we rely on the legislature with policymakers who, as it pertains to the intricacies of criminal justice system, if they aren't practicing it, they are laypersons in this field, respectively.
Mhm.
What would be focal points that you'd highlight from your book when talking to these individuals?"
Well, I mean, first of all, everything I just said, the value of public defense, how with a little bit of public defense funding, they can make a lot of magic happen. I would also focus, there's a lot, the first half of the book is the problem. The second half of the book is a bunch of solutions. So for
Hmm.
lawmakers who are like, I don't know a ton about this, I would just like the best supported policy planks you can give me so that I don't have to do the research myself. That's literally the second half of the book, just hand it to them. For lawmakers who are like, our system is fabulous and just and producing justice, and it is great, and America is amazing. I would really want them to dive into the first half of the book, which dismantles a lot of people's incorrect notions about how much justice you can find in the system, about how it operates, about the quantity of bad forensics or completely ridiculous discovery rules. I mean, some things that, like, if you look too hard at them, they suddenly become so appallingly obviously unfair that it's astonishing we've kept them for this long. Discoveries in that category. Why do the criminal courts have different rules of the game than the civil courts? Why does civil court say, hey, if y'all want to go to trial, show each other your evidence? And the criminal court say, well, show this, not that. Show it at this time, not that time. Oh, and by the way, there's a whole bunch of stuff you don't have to hand over until right before that witness actually testifies. The rules are ludicrous because they were informed by a very motivated prosecutor who in 1939 fundamentally changed the rules of practice for criminal court versus civil. And once people know, oh, our practices aren't our practices because they're the best or they're the most fair, they're just the ones we got stuck with by history, which unfolded through periods of time where equity was not an American strength. I think that can be really illuminating for a lot of people. Plus, there's memorable details. Like my favorite being, a lot of lawmakers think of drug labs and forensics labs generally as like, whatever they saw in CSI. And then I've got a story of a drug lab that had a ventilation system so bad it was literally blowing drugs around the lab, just contaminating every sample in there. Some examples are more grim. Sante Tribble, who did over 20 years in prison because of hairs that turned out to be not only not his, one of them wasn't even human, it was a dog hair. So I think there's a lot of memorable stories that help people internalize the idea that the
Hmm.
system is almost cartoonishly far from what we portray it as.
Mhm. Thank you. Yeah, I totally agree about the stories, and I also think I appreciate you elaborating on the public safety point,
Mhm.
particularly because what that amounts to is not just a critique of the system, but a sense of a vision for the future also, or a sense of an alternative. And it's very sort of completely realized in the book. And also speaking as somebody who's supposed also very specifically focused on public defense, it is something of a paradigm shift because almost all of the policy conversations we have about public defense, even the sort of very well-meaning ones, uh, don't always go for to this public safety point.
Yeah.
Um, I wanted to ask specific. I wanted to build on Cody's question a little bit to say that another thing we're interested in here at the center is this. the National Public Defense Workload Study, which Malia Brink and Cynthia Lee on our staff were both co-authors on, and also which I know we're shortly intending to build out and to publish a website guiding public defenders on how to apply these standards to
Mhm.
their own workloads and in order to understand what deficiencies they might be working under. Um, and so I wanted to promote that resource to everybody incidentally. But also, actually, the question I wanted to ask for you, Emily, which still builds even more on this public policy question is, this professor in NYU just a couple of weeks ago, Ben Polk, published his estimate of what it would cost to implement the new 2023
Mhm.
caseload standards nationally, and he thought it would be about $28 billion compared to the present spending on public defense, which nationally is about $6 or $7 billion.
Mhm.
So I wanted to ask you to perhaps cap off this policy conversation. If you were in a room with policymakers and you needed to persuade them to increase public defense funding to $28 billion nationally,
Mhm.
what would you say to them?
I mean, first of all, I'd say everything I said in my public safety answer because I think they are really underutilizing a resource that has the ability to massively improve the lives of their constituents. I would also emphasize that, like, the criminal court system makes them look bad. When you think about it, like, most people's experience of government is the DMV, the Social Security Administration, and the criminal courts. Those are not great places. Like, we're not having good feelings about government when we go to those places. Um, Mostly because all of these places tend to be a lie. These are places that are held out as a helping place or a place where one can find recompense or one can find justice. And what we actually encounter is a feeling of criminalization, a feeling of condemnation, a feeling of not being heard, of being shut out and silenced. Like, in general, lawmakers tend to embrace tough on crime ideology because they think it gets them points with voters. When in fact, the first lawmaker who realizes, actually, if I made the criminal court system actually address root causes and help people, and people felt that their neighborhood was safer because of care they received, if they could confidently come to the courts for help and know that their loved one who's experiencing a mental health crisis would be immediately routed towards care instead of punished first, or if people felt like, even in the thorniest of cases, let's talk about domestic violence cases. How many people have I represented who said, I didn't just want a 5-year order of protection and jail time. I want family therapy. This is my children's father. I need this person to recover and have the care they need to reform. Like, if people started getting what they actually wanted, I think it would be politically beneficial in the form of increasing our trust in local government. Um, I would also say that's not like, that's less than a 5x increase spread across literally thousands of defender agencies. That is not, when you say, oh, $28 billion, well, literally just 1 year of the financial loss to families, just the economic hit to families is literally over 10 times that. 1 year. So families are already bearing a cost that is so far beyond what lawmakers are being asked to invest, it's blinding. Um, I think the last thing I would say is Partners for Justice has been kind of easy to build because it often feels like the basket of puppies of public defense. Like, oh, I just want to bring in some folks to like help people. And they tend to be like really motivated young people who make everyone feel happier about having to be in court and who offer really, really thoughtful forms of aid. Um, that's what a lot of this can be. Like, more hands means that the system is liberated to get rid of the cases that shouldn't be there, to provide help where help is needed, and for the things that are really scary and violent and that we as a society need to actually have our court system focus on, or for the tough calls where the evidence is difficult and technical and we need a lot of resources in order to get it right. More hands liberates the courts to actually dedicate focus where focus is due and increasing accuracy in the system, diminishing wrongful convictions. Like, this is something, again, that's not a partisan good. It's literally embracing the basic purpose of having a legal system at all. So to me, there's really the only argument not to do it is I'm okay with having a punishment bureaucracy instead of a justice system. I'm okay with courts that get it wrong a lot. I'm okay with pretty much all low-income people hating the way our community delivers a substitute for accountability. I'm okay with recidivism. I'm okay with mass incarceration. The status quo is fine. If somebody wants to argue that the status quo is fine, I invite them to do so publicly.
Thank you. I want to read out Kathy's comment. Kathy Apodaca, I hope I'm pronouncing your name right. She says she works for the law offices of the public defender in Las Cruces, New Mexico, as a social worker. And we have approximately 20 social workers and case managers throughout the state in an effort to accomplish exactly what you're explaining. It's often most difficult to get the judges on board to buy in to the concept of criminal justice diversion. It's a daily battle. Our constant mantra is fight the good fight. I wonder if you're familiar with the jurisdiction, Emily.
I am, and defenders in New Mexico are doing so much with so little. You guys are amazing. Um, some of the scariest caseloads I've ever encountered have been in the Southwest. And also, just like culturally, a lot of defenders, including you guys, are dealing with a bench that hasn't yet caught up to the rest of us. They are still in like a hang 'em high mentality, which doesn't serve anything or anyone. Um, I think one of the hardest questions I get is a version of this question, which is when defenders say, what do I do if literally no one listens to the words that come out of my mouth? If my arguments fall completely unheard? Um, and it's a hard cultural challenge, right? Because until we get a culture of a bench that's interested in problem solving and root cause thinking, you do get a lot of arguments that just go unheard. And you have to do what Kathy and her colleagues are doing, which is just keep doing it until you break through. I think part of what I love, though, about the way restorative options work is that, again, the data is there. Like over time, you get good outcomes out of diversion. One of the biggest communicative challenges we face is that the bad outcomes are much more visible to court stakeholders than the good outcomes. They are all terrified of being splashed across the front page because somebody on diversion did something bad. And none of them are caught up on the thousands of people over the years who have experienced diversion and gone home to their families and tucked their kids in at night. And so I think one thing we can do as a community is try to do a better job of making the success stories visible and bringing people in to share. I mean, judicial education is a huge lever I don't think we pull enough. When's the last time we did a training for judges where people who had benefited from diversion could come in and share how their life was changed by not going through the court system, by literally being pulled out of it before it had a chance to do its pretrial grind, right? Hearing from their kids, hearing from the kid whose dad was home instead of not home, hearing from the boss who got to keep his employee instead of losing him. Like that's a communicative battle we could do better on. I think also celebrating, I mean, part of culture change is celebrating moves in the direction we want. I think we can all do a better job of celebrating judges when they inch in the right direction. I mean, part of it is understanding what they care about the most and like how they see themselves. And it's really hard to take a judge whose whole self-identity is wrapped up with being the like tough person who's unafraid of hurting others for justice and safety. When you get that person to take a chance on even just one individual and it works out, and you're able to, help that individual write an op-ed about the judge who gave them a chance. How can we create positive feedback loops that really, really shift the culture of what judges are going for, what kinds of merit badges they're trying to collect? It's slow progress. I mean, that's one of the hardest things about doing this work is you got to fight the good fight day after day because it's going to take years to change the culture and the way you need to change it. But it is working. I mean, those of us who are a little bit old like me can think back to how things were 10 or 15 years ago. If you told me 10 or 15 years ago, hey, Colorado will have gotten rid of qualified immunity and like court systems
Mhm.
pretty much everywhere will have mental health courts. Like the fights we were fighting back then are unrecognizable today because so much progress has in fact been made, even though we feel so helpless so much of the time.
Mhm.
So take the long view.
Yeah. I wanted to ask about some of your opinions about the profession and how it needed to change, and you're beginning to sort of address, what you would the messages you might have for judges and so on. One other related theme that you do address in the book has to do with the diversity of the lawyer profession.
Mhm.
And particularly given that Kathy's from Las Cruces, I don't know much about that particular place, but we think a lot at our center about the shortage of lawyers in rural areas.
Mhm.
You allude also to the simple lack of racial diversity, particularly in the profession, and gender and sex diversity as well. And we've been thinking about programs and pipelines and scholarship opportunities and all sorts of ambitious sort of proposals for things that could actually uh, modify the membership of the judiciary and modify the membership of the legal profession as a whole. I wonder if you have thoughts or wanted to expand on either what you thought the pathology was or what the solution might be.
The pathology is obvious to everybody. It's a really, really white profession because it's super hard and expensive to go to law school, and it takes a lot of privilege to get all the prep you need to pass the hurdles to get in and then pay for it.
Mhm.
Um, but I think we've actually, there's been a lot of innovation in recent years, and we actually are starting to see real change. We're starting to see a really different bench. That was actually an argument I was making recently. There's a program called Learned Hand, which gives me the heebie-jeebies. It's an AI program that will let judges put your briefing into it, and then the AI will tell them how they should rule and give them a proposed ruling. And obviously, that's terrible for many, many reasons. But one of the reasons I really hate it is that what is the AI using to give its decision? The last 20 or 30 years of case law, right? Who made that? Who made that case law? We're at a moment now where such amazing strides have been made. I mean, I'm the beneficiary of two different black jurists who were absolutely groundbreaking to get to where they were in the moment they were in. Judge Thelton Henderson, who I clerked for, and Judge Leslie Harris, who is literally responsible for me being here right now. Um, we are seeing more judges coming into the profession from a diversity of backgrounds and life experiences and perspectives, not just racial diversity, but more public defenders on the bench, more people who represented individuals instead of the government generally. When we offer technology that will amalgamate the opinions of the lily white generations of judges that came before and sanitize that by making it into a presumably neutral AI recommendation rather than an amalgamation of past perspectives, which may no longer be innovative or applicable, we're doing ourselves a real disservice and we're undermining the very, very palpable and fantastic strides we made as a community to make our community more knowledgeable. I use the word knowledgeable instead of diverse when I can, because that's actually what we're talking about. I really hate it when people think of this as like a woke box checking exercise. Because that's not what I'm talking about. What I'm talking about is people with different life experience know different stuff. you know? And I want their knowledge in the room because the whole job in the room, right, is deciding from one's own life experience how the strictures of the law should or should not be applied to a human being. The more knowledge and difference we have in that group of deciders, the better our decisions will be. So I think we're headed in the right direction if we don't completely shoot ourselves in the foot by handing things over to the robots. I also will say with great pride that one of the things I love about PFJ is that we're bringing a really cool, diverse group of new professionals in
Mhm.
to work directly in public defense. And then we actually have capacity on our team to help everybody get into the grad school of their dreams thereafter. So we're sending a lot of really, really cool, exciting, brilliant young people who have already worked in public defense by the time they're applying to law school out into the profession. Like 60% of them go on to law school, and another huge chunk become social workers in public defense and mitigation specialists. So I'm very proud of the role that PFJ has played personally in increasing the knowledge base of the profession.
Well, if any of them want to be statisticians, you please let me know.
Definitely.
Also, if they don't, I do understand. Um, That's awesome though. I mean, that's part of the answer is always just start where you are, right? Start at home, start doing the work yourself. I really appreciate that. I do want to make a last call out to our audience. Please do keep putting your questions in the chat. We do still have time. We can still address them. I I did want to ask what what your message might be for not public defenders, but actually the people who make courts run, court clerks and judges. And the reason I wanted to ask is, again, at the center, we're quite focused on these very early stages in cases where we recognize and believe that access to legal representation is so important. But so often, also, what we've learned, of course, is that before a person gets access to an appointed lawyer, for example, the gatekeeper very often will be a court clerk or will be a judge. And there are at least places in Texas where it appears that those gates are quite firmly shut. And there are places in New York, the other place where I work, where courts are just organized in such a way that they're very inconvenient. I mean, there's so much that you could say, really, to those people about the way that the power that they have to distribute the justice system and make it accessible. I wonder what message you might have to those people about the way they actually go about their work.
I think those of us who are on the side of liberation need to be really kind in how we approach where people are mentally who are not on the side of liberation already. And here's what I mean. If you spend your entire career ushering people into jails, taking them from the courtroom into holding, escorting them down into the bowels of holding downstairs, or you spend your career doing the paperwork that condemns people, or you spend your career as a judge having to sentence people to time. And this obviously applies 100-fold to prosecutors. You have to believe that punishment is safety. You have to believe that when you grab someone who is struggling and you restrain them and you force them into a cage, that you're doing something that is for the good of the community, because otherwise you can't go to work in the morning. You can't do that job. And we've developed an entire language of our system that's all about shielding system workers from the actual feelings of what they have to do. So we put a person in custody. Custody is usually a word about love and children, and like you want custody of your children. We use a special housing unit, solitary confinement, right? Like we use all of this language to kind of anesthetize system workers. And I think that when we try to convince people that care is safety, we are implicitly saying, and punishment is not, which means the thing you've been doing for 20 years hurt a lot of people. And I know you didn't mean to, but that's what the effect was. And I don't ever say that over, but I feel like we have to be cognizant in how we approach these conversations, that is implicit. And I think we have to, in trying to support people to embrace more evidence-based practices, we have to remove stigma. We have to make it safe and inviting to say, hey, there's new data on this. Here's what we know now.
Mhm.
We can change. We can do better. You've been trying so hard to do the right thing your whole life. You can do better now. I think that's a really important part of the conversation.
Thank you. What a thoughtful response. Um, I want to go to Ron in the chat first, and Jamal, I do see your hand also. Ron actually asked something that I think you may have just covered, but I want to give you the chance to respond separately because he added, how should conversation with prosecutors
Yeah.
who have such power in our system be conducted?
I feel terrible for a lot of prosecutors. In working on the book, I allowed prosecutors to contribute anonymously when they wanted to, so that they could speak really freely about what they'd experienced. We really, on the defense side, underestimate how much strain the people are under who go into prosecution to change the system from the inside and then like run face first into a wall of middle management who will not allow them to do anything restorative and who tell them that their professional future is based on their ability to convict and punish, not on their ability to be creative or responsive or smart. And I think we see the same problem happening with people who run for office and get elected on a restorative platform and then run face first into a wall of middle management who do not want to enact restorative practices. And so I think when I think about conversations with prosecutors, I mean, on a day-to-day, like interacting with prosecutors, know that person as well as you can, know who you're interacting with, figure out how they see themselves, what they believe in, what they're committed to, and use that in your argument. On a macro level, though, I think we need to be doing a better job of ousting the punishment as safety perspective so that that wall of middle management who control advancement in the profession is weakened. Until we can change the incentives of prosecution, until we can make a world in which prosecutors get promoted for root cause thinking and smart diversions and evidence-based practices instead of how many people did you convict this year, until we fix that culture problem, we can't protect the best people in that profession. So I think part of our job is to protect those people by changing the narrative on that outdated perspective, which dominates so many offices.
Thank you so much. So I know I have a final question, but Jamal, please go first.
Sure, sure. Emily, thanks again for stopping by. We really, really appreciate it and have absolutely enjoyed the conversation thus far. My question for you is a selfish one. I work in comms for the Decent Center, and um, I am just in awe and insanely jealous of the amount of people you get to pay attention to this issue.
Yeah, thanks.
I mean, it is absolutely incredible. I worked as a journalist before this, and trying to pitch a criminal justice story is rough. Trying to pitch one that is focused on systems, that is focused on these sort
Yeah.
of intricacies of the justice system is nearly impossible. And so, give me your advice on getting people to one, care about this issue, to two, sort of
Yeah.
build up a following around this and take what is complicated and nuanced and make it digestible for an audience.
Yeah. So the formula that's really worked well for me is a surprising fact, validation about who I am and why I know that, and a little bit of storytelling around how stupid the problem is, and then an easy to do action that people can take. That's really what I try to do in short form online communications, activating folks. You know, I'll see a really dumb stat and then I'll try to come up with a hook that really highlights the idiocy of the policy. Um, I also think, there's the true crime world has done a really good job with people's native curiosity of like, what's really going on in these kids? Let's get all up in somebody else's life. And, but I think to the extent that the theme with the public is like, we're revealing, we're opening up the frickin' wall here. What is happening? Oh my God, it's a nest of rats. Like really revealing the dirty secrets of the criminal court system. That has been very powerful. Another thing I try to really emphasize is that this is not somebody else's problem, and this is particularly racialized. There are a lot of white people who think, well, it's not really my problem. And then they emotionally check out. Even if they think they are very good white people, they are emotionally checking out because they don't think it's about them. And so usually I will actually start, if I have a big point to make and I want a big group of people paying attention, I will often start from the scale of the system. We live in a country where half of us have had a loved one locked up. In my field, public defense, because 80% of those folks got a free lawyer of some kind, 1 out of 3 people in America has had a loved one represented by a public defender. They don't talk about it. And what that does is that says, even if you don't think this is happening in your community, it is. People just aren't telling you. You should know about it. It could happen to you. And there's tension there, right? Because we also need to talk about this, that the system is disproportionately aimed at Black and brown families and low-income families. But I don't start there, because if I start there, people feel at liberty to check out, and I don't want them to. Last thing I would say is safety is collective. Everybody understands the idea that if your neighbor is having a mental health or substance use crisis, you're not that safe. And so even if you don't care about the humanity of my clients, even if you are just purely self-interested, their well-being makes the difference between whether you put your keys between your fingers when you walk down the street at night. So that and like say the spicy thing, it gets more attention on the internet.
Thank you, Emily. That's a little bit of secret sauce right there. I'm going to head to Instagram right now. That's awesome. So I know Divya is going to share the link for people to actually go get your book, and we've had some folks drop, so I know that we will also distribute it to the folks who registered.
It's on sale on
Um,
Amazon right now too. If you're not like if you want to protest Jeff Bezos, I support that. But also the book is only like 19 bucks on Amazon right now.
right. So I wanted to add, we've started with you as a defendant, we've gone through you as a public defender, you've become this policy, what is the word? Critic
You can
maybe
call
is
me a
one of the
wonk.
words. Yeah, a wonk, sure. Yeah. Um, and also your vision has sort of expanded to talk about the transformation that can happen with public defense and all of the things that can be added to it that can change people's lives, but then also communities. And so I wanted to ask, um, the next thing might be dealing with these problems on the front end. So, what do you think you're
Yeah.
doing next?
So the next thing I'm doing is actually in September. If you have a child in your life, I have written a middle grade novel to teach kids about accusation and criminalization and how to protect themselves and each other. We do this a lot for teenagers, but we should be talking to 8-year-olds because criminalization starts really, really early. I can't tell you how many kids I represented when they were 13, 14. Their first contact with police was when they were like 8. So I've written a book called Andromeda Diaz and the Reasonable Doubt. Divya, maybe you can put a link to that in the chat. It's a mystery novel. It's sort of like Harriet the Spy meets Perry Mason. It's about a little girl whose parents are public defenders, and when her friend is accused at school, she knows what to do. So my hope is that it's actually going to be a series. The first one's coming out in September. The next one's coming out next year. That through this series, I can start doing a broader know your rights effort with the little ones, the really little ones. I want kids to not only know how to like stop, look, and listen at the edge of the street. I want them to know the magic words of I want to remain silent and I want a lawyer. Because right now, 90% of children waive their right to counsel if stopped by police. And we have millions of children in this country going to schools that have police but no nurses or police but no counselors. So my next effort is to protect our kids and teach them their rights and make invoking your rights cool.
Amazing, amazing. Thank you so much. Yeah. I appreciate the holisticness of your vision, Emily, but not only is that the name of your, your discipline, as it were, but you've got this moment where you're reacting to people in crisis and then finding them routes back into stability, I guess.
Thanks.
But now also thinking about averting crises before they happen.
I got a
So,
kid of my own. I'll tell you, I did get a call from the school. The school police officer tried to say hi to her, and she said she wanted to remain silent and she wanted a lawyer, and her lawyer is her mom, and her mom's number is, and then she gave my cell phone number. So, I have to say, I'm just following the trajectory of my natural life.
incredible, incredible. Well, thank you so much. Thank you for everybody for coming. And thank you so much, Emily, for spending time with us and for sharing your work and your wisdom. We certainly do appreciate it.
Thanks so much for having me, guys. It's good to see you all.
Bye bye.
Bye.